Hey everybody, welcome to this week's live video. I have Christina Scalera on the other line. Well, other line. I like saying that, but it dates me when I say that. And she is going to be talking to us about trademarks and copyrights and all the legal stuff you need to know about, selling your work or not breaking the law. And I'm super excited to talk about that because I think it's something a lot of us need to hear. And a lot of us aren't even aware of the fact that we could be, I don't want to say breaking the law, but it is breaking the law. So anyway, yeah, we got a lot to cover today. As always, make sure that you hold your questions to the end. We're going to have an opportunity for you guys to ask questions to Christina, but we'll be answering the ones that were pre-submitted while we're on here. And yeah, I hope you guys enjoy this. I'm going to get Christina up on the screen right now. Welcome, Christina.
Hey, Becca. Thanks for having me.
Yeah, of course. So just for anybody who doesn't know you, can you give us a little rundown on who you are, what you do, and maybe how you got your foot in the door with like the calligraphy world?
Yeah, sure. I think I'd like to be in a lot of your shoes. So I am an attorney. I graduated from law school at Emory in Atlanta. And once I graduated, I got my dream job. It was working in-house. I apologize. I'm a little congested today. I don't know why, but not sick, just congested. Anyway, my voice is like off. But so I got this dream job. I loved working there until I didn't. And it was for a lot of reasons that actually have to do with copyright law. Becca and I have talked about this before, but I didn't like sending the letters that I had to send to people that were doing really good work like you're doing on Etsy and in different places. It just kind of hurt me. So for a lot of reasons, I decided to leave that job, and I fiddled around for a while. I was like, what am I going to do? Got my foot into the calligraphy world. And I really thought I was going to be a calligrapher for a while. That didn't quite work out for a lot of different reasons, but it did help me to found what's now the contract shop. And so that's my business. I sell contract templates to creative entrepreneurs like you guys, calligraphers, graphic designers, photographers, that kind of thing. So that's my business now. And what I aim to do is to help make the legal stuff a little bit more approachable, a little less scary. I think a lot of us have this story in our minds that we're not good at it. It's like math for a lot of us. It's like, oh, I'm just not good at that. But in reality, it's just a lack of exposure, a lack of practice. And it is something that is essential to have if this is going to be part of your life, part of your business, if you're going to be posting things online of your work, or if you're going to be selling things, it's even more important. So thanks for having me, Becca.
It's my pleasure. I am really excited for people to hear more about this topic because I think a lot of people don't even realize that they could be screwing this up. So first things like right out of the gate, we have a lot to talk about, so I think we should just jump right in. But I got a lot of people asking right off the bat, if you are not selling your work, does this even apply? Like, are you allowed to use things that are copyrighted, copywritten, covered by copyright, however you want to say it? Are you allowed to use that if it's for your own personal use or if you're making a gift for a friend? Like, does this only apply if you're selling it?
Yeah, so so there's the legal side of things, and then practically speaking, I'm a big fan of practicality. So the legal side of things is this is going to apply to anyone, anywhere, anytime. It doesn't matter if it's only going to be seen by your grandma or your cousin or your friend or whatever. Practically speaking, I think that's a little harsh. So, for example, I had a gal call me one time, and she was making these like gift tags that had someone's copyrighted work very clearly embedded in the gift tags. It was for like a small baby shower of maybe 10 people tops. And she asked if this was okay. And so, legally speaking, is that okay to use without a license? And a license is, we can talk more about what that is, but basically it's getting permission, maybe usually for a fee, to use that copyrighted work on your design. And practically speaking, I just think that's not going to be a great approach. You probably aren't going to contact like Marvel Comics to get permission to make a gift card or like a gift tag that's going to be seen by, your bachelorette party or whatever. So is it important for you to pay attention? Absolutely. This is going to apply whether it's commercial use or personal use. But as far as like can we bend the rules a little bit? If it's just going to be seen by our closest friends, or this is a card that's going directly to my friend and that's it, and she's not like an Instagram influencer who's going to repost it to her 500,000 fans, I think that goes a little bit overboard to say that you have to have a license in that situation.
Okay, so pay attention if either way, pay attention. But if you're just giving it to your mom or whatever, and your mom's favorite superhero is Superman, for example, you don't have to like go and get permission for that.
I just think it's overkill. Yeah. I mean, if you wanted to do it right, that's what you would do. But like, who's going to see it really?
And I think it's either way, it's important for people to pay attention, because if it's like a gateway drug. If you start making that stuff for your mom and someone sees it and they want one and maybe they're willing to pay you $7 for it, that's when you need to start paying attention. So it's good to have it in the back of your mind either way.
Yeah. And these really popular characters or brands or just things that you might want to include and improve upon. Now, we're not talking about quotes because that's a little bit different, but like these characters that you can identify and maybe you want to use on your designs. Those types of companies actually have really strategic licensing procedures that are pretty easy to follow. So it might be out of your budget when you're first getting started, but it is something that they deal with a lot, and there is a procedure for it because it happens so frequently.
Okay, so that covers that. Either way, you should pay attention. But maybe let's back up a little bit and like start right from the beginning. Like, what is a copyright and what do people need to know about it?
Yeah. Okay. So a copyright is simply an exclusive license to use and enjoy the work that you're creating. And so that's a fancy legal way of saying when you create something, when you create a photograph, when you create a quote, when you create a really beautiful, fanciful print or a blog post or anything like that, those are all things that are considered works. So in the US, we don't distinguish between works and visual works. Other countries do. So if you're outside of the US, there is a little bit of a difference there. There's more rights that are afforded to what's considered a visual work. So those are the types of things that you guys would be creating, very visual, beautiful things versus like a blog post where it could be in any size font or color or whatever it is. So that's just what a copyright is. It covers those types of works that you could be making for a client, for yourself, for your own blog, for your website. And so that is, I don't know if you want to jump ahead to trademarks a little bit, but a lot of people get trademarks and copyrights confused because they're kind of like sisters. So they have different purposes, they have different reasons for existing, and they also have different utilities. And so you guys are all familiar with like the names of your businesses. That's a third thing to take into consideration. So we have copyrights, which are the things that you're actually creating in your business. You can think of it like that. So the photographs that you're putting on Instagram, the quotes that you're lettering, the client work that you're creating, those are all copyrighted works. The second thing that you might have in your business are things like trademarks, which are things that identify you and set you apart from anybody else in the marketplace. So if you're buying one of Becca's workbooks, you're going to be really disappointed if you thought it came from her and it actually was ripped off and sold by somebody else, and it was like an inferior product, but it had her name on it. So that's the thing that the trademark is able to distinguish. It's this phrase or a logo. It can be a short tagline. It can be just like one word. So whatever it is that distinguishes your product from somebody else's, that's the trademark. So those are usually shorter. Yeah.
So for me, for example, like to give people a concrete example, show me your drills is trademarked. So like, and actually so is the Happy Ever Crafter, obviously, but show me your drills as like my product line is trademarked. So if that is written on anyone else's stuff, they're ripping my program off.
Yeah. And so that's a good example, because if, for example, you downloaded a workbook from, you just found one on Pinterest, you downloaded it, it said, show me your drills, and you're going through it and you're like, wait a second, this is like not the same as the other show me your drills workbooks. That's a really good example of trademark infringement, potentially, where you thought you were buying a product from one manufacturer and you were actually getting it from somebody else. So that's actually the perfect instance where we look as an attorney. I'm looking for any kind of confusion like that. So if you've ever gone into a drugstore or well, you guys don't have Target up there, but if you've ever gone into Walmart or Target or giant tiger or whatever. And you've grabbed, like, I've actually gone in and bought like a bottle of what I thought was Benadryl because it was like pink and branded and used the same font and everything. And I walked out and it wasn't Benadryl. And for me as a trademark attorney, this is like kind of snobby, but I always look for the labels and I try to buy the brand names. So I always thought I was buying Benadryl. I got the knockoff brand. That's a great example of when the trademark would have been infringed. So for you guys out there, if you're starting a business, even if you don't have a business yet, but maybe you're just using an Instagram handle or you have a blog or something like that, a trademark would come in handy when you're trying to display your stuff out there for the world to see, and you want to make sure that they know it's yours. And then finally, a trade name or a business name, or an LLC registration, sometimes a DBA if you have one of those. Those things are all business names. And so a trademark doesn't have to necessarily be a business name. And so I just want to lay those three things out there because they're all very similar when we first look at them, but when we break them down, they're very different. So for example, the name of my podcast is Creative Empire. That is our trademark. However, the business that owns that podcast is RPCS Holdings LLC. So for example, you're not going to see RPCS Holdings and think it's the Creative Empire podcast, but you could see Creative Empire and then realize later that it's registered as a business to a different name. And then the content that we create, the podcast, the transcripts, the graphics, the photos, the freebies, anything like that, those are all copyrighted materials that are created for that. So hopefully that's an example that can give you a little bit better idea. So for example, in Becca's business, real quick, she has the Happy Ever Crafter. You go there, you know it's her website because it has that logo, it has that name at the top. That's the trademark. The name of your business, I actually don't know, but maybe it's registered as something different. It could be the same, but it doesn't have to be. It could be just like Becca's Awesome Calligraphy LLC or Becca's Awesome company. It doesn't have to be the same. And then
how did you know? How did you know that's my company?
Yeah, no. So then, but then all the workbooks that you're producing, everything in that workbook, anything that is on your blog, this broadcast, those are all copyrighted works that the Happy Ever Crafter then owns. So hopefully that breaks it down a little bit.
Yeah. So we have copyright, trademark, and trade name. I think the most relevant, obviously, for this audience and this conversation is the copyright.
Absolutely.
And I actually wanted to ask you, as you were talking there, I think for a lot of people here, it might not be a business yet. And I'm hoping a lot of people will turn this into a business. But for now, like, these things still apply, even if it's just something you're posting on Instagram, right?
Right. Yeah, that's a great point. I have it later in the outline I sent to you, so I don't know if you want to cover it now. But what I will tell you guys is I see a lot of people reposting things without permission. And so they're reposting with credit, but without permission. And that's one of the worst things I feel like you could do on Instagram, because you've basically just told someone that you're infringing them and shown them exactly where the infringement has happened. And this is really, really easy to get around. Usually it's just as simple as a DM or even a comment on a post like, hey, can I repost this? Or if you have a good relationship with that person, maybe it's an ongoing thing. So for example, like a couple photographers that are in my area, I have a relationship with them. We just have an understanding that I can use any of their photos that they throw up on Instagram. So that's probably a better thing to do if you're reposting someone's quotes or lettering or pictures or whatever, than just simply reposting and thinking you're doing a good thing by giving them credit and sharing their work out there, because they're the owners of that work, just like you're the owners of the works you create. And you don't know if they want it reposted or not. So,
okay. So it does apply big time to Instagram for sure, which I think a lot of people don't realize and yeah. Is super important. But yeah, so maybe I'll just let you jump into your discussion about how to actually use a copyright.
Sure. Yeah. So how to actually use a copyright. First of all, I think we have to talk about how you create a copyright, because a lot of people have this idea that like they need to register it or whatever. The way that you create a copyright is simply by creating, and that's super basic, super easy. You are simply on your iPad or pen to paper, writing something, drawing something, lettering something. So that is where the copyright is created for the first time. It doesn't have to be published. It doesn't have to be public. It doesn't have to be on your Instagram or on your blog. There's no requirements like that. It just simply has to be created. Proving the date that you created it is a little bit more difficult if you ever needed to do that later. If you've only, hand lettered it and put it in a file somewhere in a drawer, then say online. But that is how you create it. When you create a copyright, especially when you're working with clients, if you're not working with clients yet, this isn't a huge deal. You're just creating for the sake of creating, maybe to get more followers, views, whatever, that's great. But if you actually are working with clients, it needs to be really clear as to who owns that copyright. Because if there's no contract, it could be considered a work for hire. If there is a contract, but maybe you don't understand what your copyright clause says, you could be assigning the keyword is assigning a copyright to someone or selling a copyright. So an assignment occurs when you are creating a work for a client and you're telling them that after that work is created, after they've paid you, they actually own it. You no longer have any rights to that work in the case of an assignment or sale of that copyright to that person. It's almost like they created it themselves, and you don't get to keep that. You don't get to continue to display it. You could be infringing your own work if you assign it to somebody else and you haven't retained any rights for that kind of display. So that's really important if you are working with clients, is just to be aware of who is actually owning the copyright afterwards. And there's definitely ways that if you want to keep that copyright yourself, if you're planning on using that design in future work or in a template or for other clients or something like that, there's definitely a way that you can keep that copyright and then just give your client basically the ability to use it in the way that they need to. So
can you give us an example of like something, an instance where that would happen, like that as it relates to this field? So would it be like, are you talking about something like maybe a font?
A font could be one. Possibly where I see it a lot is when people letter like a logo for a couple for their wedding, and that person, maybe the logo was originally only intended, it was originally only intended for, say, like the invitation suite, and the calligrapher shows up to deliver, the signage or whatever, and they're seeing the menus and the table, like the place cards and the seating chart or something like that, has the logo on it. And so that's an example of where the client is actually, if you as the calligrapher are keeping the copyright, that's an example of where the client is infringing your copyright. So that's an example of where if the client's just looking, they're just kind of fishing around for the bare minimum, and you can get a sense for that. You might just ask, like, what are you planning on using this for? Like, make sure that you're getting paid the right amount for what you are giving that client, because it's not, I've seen it happen to calligraphers, and it's not a pretty thing when they create like an invitation. This is even worse than creating a logo. Like, you create an invitation suite and somebody takes a picture of it and uploads it to their computer, and then they like Photoshop it onto their own menus and like just different stationery that you didn't create as the calligrapher. So that happens all the time. And you just have to be really clear about that in probably several instances with the client, whether it's your contract, a client magazine, a client consult. Those are all instances to possibly bring this up, especially if you feel like that's the place where you have an opportunity to talk about it with your client.
And that stuff being in a contract or your client magazine or your communications is a topic for a whole nother day that I'm going to have to get you back on this conversation for. But yeah, I think it's really important to know that. And like, I mean, people feel, I think people are probably watching this feeling overwhelmed, like, oh my God, I didn't realize that I should be stating these things, or that I should, and it don't freak out. It like will come with practice. And I guarantee you it'll happen to you once and you'll probably fix the problem at that point and just never do it again. So like, it's not something that you are expected to just understand and know right off the bat. So anyway, let's keep the conversation going.
No, but I just want to highlight that. Like I think this is a practice. I mean, that's why they call it the practice of law too, for us as well as attorneys. And it's something that you're learning about, growing. The field is always developing. And so if you're feeling overwhelmed, it's good to know that it's normal and that you just have to push through it. Like, you might not understand all of it, but the fact that you're trying to have these conversations with clients, or, just trying to learn about it, sitting here watching this right now, is really, really crucial. And you're doing a great job.
Okay, well, I'm not doing much. You're doing the great job, so I'll let you keep talking about that. Like we were talking about how to properly use the copyright. So, how do you know if like you own that copyright or if the client does? It's just in your contract.
Yeah, if you have a contract, it should be clearly stated in that. And again, like just a reminder, I'm not giving them legal advice. So I'm not saying like you have to have this or you have to have a contract or whatever. But what I will say is that that is a great place to distinguish who owns it definitively, like once and for all. If you don't have a contract, if this is something informal, if this is something that you just don't feel like you need to, it really depends on the nature of the work. So if this is like an ongoing, like you're creating work for this person, it could be considered a work for hire, especially if they are a company themselves and it's not just like two people personally interacting around this. So if you want to maintain the copyright, it's a really, really like keep it basically. It's a really good idea to have it in writing somewhere, whether that's an email, a contract, whatever, to make sure it says like, I own the copyright in any works created or this work created or whatever it is. You're just getting the ability to use it for blah blah blah. Your wedding day, your friend's bachelorette party, like whatever it is. So it's a good idea, even if it's not a contract, to have something in writing that talks about you as a calligrapher owning the copyright.
And what if it's not for a client? What if it's just I created this like tiny painting with a little bit of lettering and I put it on Instagram? Like that's still I have a copyright over that, right?
Yeah, I mean, in that case, are you like is this an example of where you're like encouraging people to repost and give it away or something?
No, not necessarily. Just
Not when you change it, honestly, but
say I
yeah.
put it on Instagram, and you had said earlier that you don't have to register that copyright. Anything I created is automatically copywritten,
Yeah,
copyrighted, whatever, copyrighted. So what happens, if someone reposts it? Like I don't have that in writing anywhere saying that, I own that copyright. It's just a thing.
Yeah,
so
I see what you're saying.
how does that whole thing work?
Yeah, I mean, in that case, it's yours. It's not like this client service provider relationship where there's no money. It's just clearly yours. Just like I put a blog post out there on the internet, or you post photos of your work, or you post a photo of yourself. Like those are the types of things that they're yours, and then anybody that's using it would be considered an infringer. So the standard for infringement, just to back up a little bit, as we're going through like what copyrights are and how to use them. Let me shut this window real quick. Beautiful day in Colorado until it gets noisy out there. So what happens is if you are using a copyright and you don't have permission, you're just reposting it, that is where you run into trouble as an infringer. And so the reason for that is because infringement is there's two factors to it. So you have to have access to that person's work, which is pretty obvious and open on things like Instagram, Pinterest, right? Like you're following them. We can see that you've looked at their stories, their profile, whatever it is. That's access, or just the fact that it's so publicly out there. The second thing is substantial similarity. And so this is where people get hung up because they're like, oh, well, I changed it 30%. Is that enough that it's no longer infringing? There is no like percentage or exact amount that you can change something where it's no longer substantially similar and considered copyright infringement. It is very it's determined on a very like one-to-one factual basis in each instance where there's an alleged infringement. And so in order to infringe someone, like if you're taking a screenshot and reposting it, I don't think there's anything more clear about the fact that that's infringement. It is an exact copy, just like, back in the old days, you would put a picture on a Xerox machine and copy it. That's infringement. Now, what would actually happen? I mean, that's like a whole nother discussion. But if you're looking at, can you use something, who owns it? That's a pretty clear cut. Like you posted the image, it's your work, you own it. Someone else is just taking it and we're using it for whatever purpose, just to get followers or create a caption or whatever it is on their Instagram account. And you can allow that or you cannot. The cool thing about copyrights is if you allow that, it doesn't diminish the fact that if the wrong person uses it, you don't lose any rights with copyrights. So if 500 other people repost an image that you put, like a quote or something like that that you put on Instagram, and one person who's like your biggest competitor or something does it, you don't have to go after all 501 people. You could just go after that one person for the instance of infringement you're not comfortable with.
And then I have one more question. Someone
Sure.
asked in here about Etsy. So do you know anything specific to Etsy's terms? Like if you have a print on Etsy and someone buys it, so she said, I won't have a contract with them. So is there a chance that they are taking my copyright by buying my print?
Yeah, I see what you're saying. Um, I am not familiar with Etsy's terms, to be totally honest, but yeah, no, I mean, I'm not aware of a situation where that would be considered a work for hire. I think it's pretty well established at this point. Etsy's what, like 10 years old? Um, I don't think most people think these are works for hire. Usually, works for hire are more substantial, where they're actually hiring you as an independent contractor first or as an employee first. So it's not something I would be worried about. I mean, if you wanted to take the extra step and just let people know that this isn't a work for hire, that would be sufficient.
So work for hire would be where you need to like set out those terms and claim who owns that copyright, versus selling a print is like it's just automatically determined that you own that copyright.
Yeah, I mean, they're just buying one license for it. I think Etsy even has, I'm not, and I don't know Etsy's terms off the top of my head. I haven't read them probably in 6 months, but I think they actually do talk about licenses. At some point, no, that was Creative Market. They were selling commercial licenses. So
It's the same on a bunch of those platforms. Like if you sell a font, for example, and someone buys your font, that you are purchasing a certain amount of licenses,
right.
or a certain number of uses that you can have for that. So it depends on the product, I guess.
It depends on the product. I mean, with Etsy, on Etsy, it's not a situation that is a typical like work for hire situation. I was talking more about, sorry if that was confusing. I was talking more about like someone comes to your website, they want an XYZ, they want like a giant sign for their wedding of a seating chart or something like that. Is that considered a work for hire? That's a situation where that's probably more important to make it more clear, especially where it's like basically the more custom you get, the more important it is to make it more clear. The less custom it is, if it's just like a download or you're just changing a name or a date or something like that on a print, then it's not, you're getting less and less towards the work for hire. So all I wanted to say is that especially where you're designing invitation suites, especially if it was like a commercial client on the other end of it. So let's say like, I don't know, Walmart hired you to letter their annual like banquet for employees or something, like that you were creating the invitation suite for them. That would be a situation where it's really important to get that in writing. If that's important to you, it might not be important to you. You might not ever create these Walmart invitation suites or anything similar to them again. Who cares? But if it is a situation where you're on Etsy, it's not something I would worry about. And if it is, it could just be as simple as like a one-liner in your notes or wherever you're allowed to put, like the shipping details or something like that. So.
Okay, so can you talk a little bit about, like I know you said you don't have to register a trademark, but like what is the benefit to registering? Sorry, copyright. You don't have to register it, but why would you, or why wouldn't you? Like, how do people know if they should, and on what kind of products they should or would?
Yeah, absolutely. It's a great question. So registration is not necessary. You still have a copyright no matter what. But there is a huge benefit to registering if you decide, if you're getting bigger, or if you decide to resell this down the road or something like that. So basically what happens in the situation where a lot of people find themselves in, if they're not aware, like if they're not watching a presentation like this, is what is going to happen if you do this long enough. You're going to be out there, someone's going to rip your work off. Those of you on Etsy know this is already happening. I don't know why, but Etsy sellers are just, they're the worst at ripping each other off. So I say that lovingly, but you're going to go on to Etsy one day, you're going to see your design, it's going to be on somebody else's work, and you're going to say, what the heck, like that is my work. They're reselling it. Wow, they have more sales than I do, or they have less, or whatever. You're just uncomfortable, right? It's that like gut dropping feeling when you see your work somewhere that it's not supposed to be. And so if you don't have a registration, the process looks a little bit different. You have to talk to that person. You have to ask them to take it down. You have to hope that they take it down. You have to show that you were that you had created this prior to when they had. You have to show, if you want to get any kind of money back because of the sales they've made on Etsy, you have to show how much money you've made or lost as a result of them making the same product and ripping you off. So it's a lot more of a it's just, there's a lot more balls in the air. Like it's not as clear cut as if you had a registration. So that same situation, let's say you had a registration on the design that was ripped off. What would happen is you would let them know that you have a registration for that design and that you are going to request a certain amount of money, and you can just request it. Once that registration is in hand, you can request $750 to $30,000 for unintentional registration, or unintentional infringement, which is what most infringement usually falls into. There's even another like group of willful infringement, and that's even higher. So that's $30,000 plus dollars. I think it's $100,000 or $150,000 that you can request just like that. You don't have to prove that your design was selling that much money. You don't have to prove that you lost that much money. You just pick a number and that's your request, because that's what the registration allows you to do. So now, remember, I said there's two factors for infringement. You have to show access and substantial similarity. Now you don't have to prove the damages aspect. You don't have to prove how much money it costs you and that this is going to be a worthwhile legal battle. All you have to prove are those two things, and just write down an amount on a piece of paper, and that's what you're going to be requesting for this rip-off design. So it makes it a lot more likely that an attorney is willing to work with you when they see dollar amounts involved like that, and it also makes it a lot more likely that you're going to succeed if somebody does rip you off on Instagram, on Etsy, on whatever platform it is. That you will be successful in taking down their infringing work, and that you will continue to sell your design without many, I'm not going to say any, but like many hiccups along the way of getting this other design taken down.
So how much does it cost to register copyright?
Yeah, so there's two costs in the US. And if you are selling elsewhere and you find that infringement is occurring in the US, it's a good idea to look into a US-based registration. So anyway, the costs include a $35 individual cost. So if you just decide to register like one print, one photograph, like one of whatever it is that keeps getting ripped off, that's $35. You can do it yourself. I mean, you can hire an attorney for it. It'll be probably like $200 to $400 depending on the attorney you hire. So you can do it yourself. It's pretty self-explanatory, pretty straightforward, or you can hire an attorney. They'll take care of it for you, but it's going to be a lot more expensive. Now, the other option you have is to register what's called a collection, and these are not my favorite to do. I'll show you why in a second. So a collection is a group of works. This could be, like 10 designs that you created, or literally a collection, like if you do spring, summer, fall, winter collections. And so that's the other option. So that's $55. So it sounds like the $55 option would be like a better value for your money, but I actually prefer to register the individual works, because when a collection gets registered, if one of those designs gets ripped off, you are comparing the rip-off design to the entire collection. And so if you registered 10 designs and as a collection, and somebody takes one of those designs and rips them off, they have stolen 1/10 of your work, versus if you registered it individually and they rip it off, they have stolen 100% of your work. So even though it's more like, even though it sounds like it would be a better value, I don't think it's a good idea, unless you're like, if you're looking at records and the way the music industry, because they're the most commercial, I feel like, of most of the people that deal with copyright law. If you're looking at how they register, they actually register as a collection. So every album that you listen to is registered as a collection, and then individually as each song. So that's just something to know. But if you are like, how do I manage this? Because I have like 100 designs on Etsy right now, Christina. A good thing to look for is the top selling designs, the most popular designs. If you have any on Pinterest, which ones are getting repinned a lot. If you share anything on Instagram, which ones have the most likes or reposts. it's not usually important to register. I mean, I'm not going to say it's not important. That's your personal decision, but it's really, in my opinion, like I'm not going to be out there registering my own designs that aren't selling or that nobody cares about, because those are the least likely to be infringed upon and ripped off. It's the designs that are selling really well and making money that people are going to notice, and they're going to say, I want this. I'm going to make this. I'm going to rip it off and make it my own, or I'm going to just like rip this off carte blanche. And, so those are the ones to pay attention to. So it's not like you have to spend your entire, like if you have any, you just heard Desiree's talk. If you have a budget for this kind of stuff, it's not like you have to spend it on all of your designs. It's a good idea to be smart about where that budget goes, and to decide which, maybe top 3 designs to register if that's a possibility that you're going to get ripped off.
Okay, so we've talked about what a copyright is and how to use it and when and if you should register them. But I think we should also pivot to the conversation about how to avoid infringing on other people's stuff. So especially as it relates to the people in this group who are probably lettering like song lyrics or quotes from movies or famous quotes, like Shakespeare or whatever. The first thing I want to ask is, say you're lettering a famous quote or something from a movie. If you put at the bottom the little dash and the person's name, like Shakespeare or Harry Potter or whatever, is that like, does that cover you in any sense? Or is that just like an old wives' tale that's giving proper credit? Like, I think we learned that in high school or something, and people think that it still applies.
Yeah. It's not quite the same as high school or, yeah. So it's definitely different. And this is, again, it's very frustrating, I think, to letterers and calligraphers, because it is such a fact by fact basis and situation. So no 2 situations are going to be the same. Like I can't blanket say, oh, you can use everything like from books if it's like less than 3 words or whatever. Like those are all myths. So every situation is going to be different. And the interesting thing about copyright law is that it does matter. Remember how I said it has to be a substantial similarity? So it does matter the amount of work that gets taken. And one thing to consider is, like, if this is a quote from a movie, that movie is what, 2 hours, an hour long? It's very long. It's just a very short sentence from that movie. So it's probably not going to be infringement, with the annoying lawyer caveat that if it's the most famous quote from, which of course are getting lettered a lot more often than like the dumb quotes from the movies or the unmemorable quotes, if it is like the most famous, like what's that line in The Notebook where it's like, I have loved you, I've always loved you, like whatever it was when they're jumping in the rain or something. I see that one all the time. That's the movie, like that is what makes it. And so that's going to be a lot harder to letter without any kind of accusation of infringement than, say, just like some random thing that was said in the movie. So I know that's not really exciting, or it can be even frustrating. You guys are getting this, I don't know if I can share like a screen share, but you guys are going to get, if you want, through Becca's link, she has the exclusive access. You can't get this anywhere else actually right now. So she has exclusive access to a link that's going to also give you a chart, and it's a flow chart of like what I can letter, because this is one of the most frustrating and hard things to, I guess, wrap your mind around as the calligrapher, but also you guys are here, like you want to do this right. And so this flow chart basically walks you through like a yes/no scenario of what you can and cannot do. And then if you end up in a situation where it's a quote that you want to letter, but you can't, according to the flow chart, it has some alternative options for you. So for example, these quotes that make the movie, like I am your father, like if you're going to letter that and give credit to Darth Vader, Disney is not going to be very happy about it. There's a couple ways around this. So I'm not like advocating that you get around this. I think permission is the safest, best way to get around anything that you have any kind of questions around. But if you did want to get around this, I can tell you from that former corporate experience that I was talking about is, as attorneys, we are in there looking in Etsy and Google and setting up searches and bots that are trolling the internet and looking for phrases that are commonly used. So those could be trademarks, those could be famous quotes, those could be just things that we're looking to protect on behalf of our clients. And so I obviously got out of that industry because it just made me feel icky and I hated it. But we were looking for things like that phrase I just said. Like, so if you're using an Etsy listing and it has "I am your father" Darth Vader quote, obviously that's going to help you a lot with your SEO and Etsy. It's also going to make you very easy to find if you are a Disney attorney looking for someone who's using that phrase. So those are the situations where I would be, as a letterer, I would be a little bit more cognizant of that, and maybe look for different ways to say that in so many words. And then typically, hopefully this is also a little bit encouraging. Typically, as a former corporate counsel, like the thing that we're doing is we're just looking to see who's out there and using it. And it's for us on that side, it was like a game of whack-a-mole, and it just isn't worth it to sue you guys for tons and tons of money right off the start. So typically people are getting at least one, if not like three, sometimes even up to like 5, 10. I've seen letters go out from law firms that are warning people that this is coming. You're going to get some kind of action. Please take this down. And so there is usually, I can't say like across the board because I'm not an attorney for every company ever, but typically it's just a way for attorneys to save money for their client while accomplishing the result that they're looking for, which is they send this letter to you, you take it down, the client's happy, no skin off each other's back. So I know it can be really scary to get one of those letters or to be accused of like a DMCA takedown notice on Etsy. But the thing to remember is that it's just a warning. And when it comes to the thing on Etsy, I would love to get into this as well, Becca, if we can. It's not always true. And so that creates some interesting things that happen as well. So just know that if you are looking for like exact guidance, the best thing that I have for you is that flow chart, which would be kind of hard to go over here. The only other like last point I want to make about that is I believe it's 1923. The flowchart has it exactly, but it's like any works created before January 1st in 1923 are in the public domain because copyright doesn't last forever. In the US, it only lasts for the life of the author plus 70 years, or if it was a commercial work created by, PepsiCo or Walmart or whatever, it only lasts for 95 years after publication or 120 years from the date it was created. So these things don't last forever. They expire at a certain point, and Disney's trying to rally for longer periods, but they so far have not been successful in their latest efforts. So I hope that's some kind of like relief that you guys aren't just going to get slapped with a lawsuit. It would be very rare for that to happen. I've never heard of that happening. I've never seen any kind of legal anything that advocates to do that to people because it just doesn't make sense on either side.
So, okay, so you talked a little bit about the public domain. I had a good question about this actually from Cortland. She asked, how do you find works that are safely in the public domain? Like, obviously, if it's a Disney quote or like something really, really famous, that you probably shouldn't be using that and you could get in trouble for that. But like, how do you know, if those like really famous quotes you see coming up on Instagram all the time that people letter? And like, I think it's a little different for letterers because we're really not like, I just wanted something to practice lettering with. So I started writing it. I'm not trying to make money off it, whatever.
Right.
But like, for example, someone asked here, like the quote, "She believed she could, so she did." Like that quote comes up all the time. How do you know if that's copywritten or like if is there somewhere you can go and look and see if you're allowed to letter that basically?
Yeah, this is where you guys are going to like hate me. So in the US, that's still considered copyrighted, even though it's an anonymous. I'm not aware of. Is that from like is that exact quote from like something that I just don't know about? Is it like a Jane
I have
Austen?
no idea.
So yeah, I mean, if it's in the public domain based on time, that's a really safe thing to lean on. So for example, the Bible. This is where it gets really hard because for example, the Bible published any kind of like biblical edition published 1923 or prior, like that's in the public domain. Arguably, there's been other editions that have been published since 1923, so this could be like worded a little bit differently. It's long story short, it's not something that I'm going to be worrying about as somebody who enjoys calligraphy and lettering until I start to get like some kind of notice or I'm not going to put it blatantly out there. When it comes, she was asking about how do you know specifically. So if it is based on time, that's a really great indication that you're safe to use it. So, for example, Jane Austen. What are all those like other famous? I'm like blanking right now on 19th century authors, but 19th century authors or prior, Shakespeare, those kinds of things, likely are in the public domain because they're just so old that there is no more copyright that's applied to them.
Can I
Anonymous,
interrupt you? Can I ask
yeah,
you one question?
sure.
Like maybe we should have said this earlier, or maybe this is a really stupid question, but like what is the public domain? Is this
Oh
like
no, that's a good question. Yeah.
is it like
So
somewhere you can go and see all this stuff, or is it just like in your head, you know, oh, if it's that old, it's in the public domain, which is like this intangible thing?
yeah, no, so it's not like the Creative Commons. Like it's not like a database that you can go and like look something up or check. That's why I created this flowchart because it's just it it's in the public domain if certain factors apply to it. So if it's based on time, if the government has created it, I don't know why you'd be lettering a quote from the government, but if you really wanted to, that's in the public domain. At least in the States, if somebody has like I guess, release the copyright to the Creative Commons. That's in the public domain. So those are the types of things that it's not like a database, no, that you can go and look up. You just have to know like certain factors about the work or the quote that you're lettering or the character or something like that. Like Mickey, the reason why I'm making this joke about Disney extending the copyright law is because Steamboat Willie, which was like the first cartoon that Disney ever created, is very, very close. We're within, I think, 5 years of him coming into the public domain, and everybody having access to that character. So it's been interesting to watch. Now, the other thing I wanted to talk about was the anonymous quotes, because I don't know if that, like the she believes she could, so she did. Like, I don't know if that's anonymous or not. For this example, I'm going to assume that it's anonymous. We don't really know who created it. It wasn't from a movie or something. I could be totally wrong, guys. I'm sure if I am, someone out there is going to correct me. But just assuming that's anonymous, in the U.S., it's still protected by copyright law. In Canada, the laws are a little bit different, and it's not, I believe. So if it's an anonymous author, or we just like you do your due diligence, you try to find the author or the origin of that quote, and you can't find it, it's considered. They don't call it the public domain, but it's not considered protected by copyright law. I can say that. So it's frustrating because it depends on where you are and what you're using and how you're using it, and like how much of it you're using. So there is no really black and white standard, and this is why lawyers, I think, still have a job in copyright law, because everything is so one-on-one basis oriented. So we should talk about like what you can do, because I feel like I've been talking a lot about like what you can do, and that makes me feel really like I don't like that. I like to talk about what you guys can do, what you can expect, what you can be hopeful for, what you can enjoy and continue to create. So I don't know.
So
are we
well,
cool to shift that way?
yeah, just I definitely agree. But just before we move on, I did want to ask you. So back to Cortland's question, she asked how you could find things like that. So, and we didn't talk about what Creative Commons is. So is that is a database that you can go and search if you're wondering about something?
Yeah, so the Creative Commons, I mean, I don't use it, but I know a lot of people use it for like just works. I'm pulling it up right now so that I don't say anything wrong. I would go to creativecommons.org is the link. I know that a lot of people use like stock footage and stock video and things like that. My understanding is that it's a place where artists and calligraphers or photographers or somebody can just contribute their work to the Creative Commons, and it's you can continue to use it if like it's I don't know how to put
So
this, but like
barring the Creative Commons, how else would you know if something's copyrighted?
yeah.
Like do you have to hire a lawyer to look into that if it's something that you're taking seriously, or how how does that work?
Yeah, no, that's a great question. Not something that you have to hire a lawyer for. You just find what you want to use, just like you would any other quote or saying or design or whatever it is that you're looking at, and go through certain factors. So when was it created? How much are you changing it? So if it's like a quote that's exactly from a movie, are you adding in other things that like any kind of words around it? Is it part of like, is this quote going into a larger work where you have like maybe you have some kind of explainer paragraph and then the quote and then other things. So it's no longer looking like the way it did when you pulled it from the movie. If you're using somebody's, like if you're inspired by somebody, you want to create banners or something like Becca, do your banners look a little bit different? Like, are your lines a little bit different? Um, are the way that you're putting it together, like the words and the quotes that you're using, different, or are they like exactly the same as what she's selling? So trying to change it and make it your own is really important. And we didn't talk about this, but the purpose of copyright law is actually to encourage people to create. I know it can feel a little bit different in especially if you're in the States and it's like this very litigious environment, like where everybody feels like it's out to get each other. But the true purpose, the reason why copyright law exists and why it was created, was to help you feel protected enough to create. So it's basically there to give you a little bit of a security blanket to know that like someone isn't going to rip you off exactly immediately after you create something, but it is there to encourage you to continue to create and improve upon what other people have put out there before you. And so, that's my encouragement to you, is to make it your own. So I know that's really, really difficult when you're first starting out, because it feels like you're just copying other people's work, that you have the story in your head that you're not creative enough, or you're not like this person or that person. And so it can be really, really difficult to step into that and start to make things your own. But I think as you get more and more advanced, or just like the more you practice, the more you put yourself out there, the more it's going to become your own work. So your flowers are going to start to look a little bit different from Becca's or from other people in the group. Your watercolor colors are going to be a little bit of a different hue or palette than what other people in the group are using. And so the blessing and the curse of us trying to like make it as calligraphers is that nobody starts out with 100,000 followers. Like that happens over time, and by the time you get to that point, usually you have stepped so far into your own style, and that's the reason why you've gotten all those followers. That's the reason you've gotten all those clients, is because your work does look different. So hopefully that's encouraging to you guys, that if you are out there and you're like, what do I use? I don't want to use anything. I'm all scared right now. First, that people aren't going to come after you for money, most likely. Just from the start, they're going to give you some kind of warning, or some kind of takedown, or like, just please take this down, whatever it is. And then the second thing is like, it should be an encouragement to help you create more and like step into your more creative side, so that you can change things to the point where they wouldn't be considered infringing under, any circumstance. Whether that's like adding more flourishing or details to your prints or your quotes, or using the quotes in a new and exciting way where it's like matched with other quotes or something like that. So I think there's a lot you can do. I think there's a lot more you can do than you can't do. And it's just, if you're thinking about using something, look and see, is this something I can use to start with? And if it's not, like, how can I change it? How can I be creative? And how can I improve this so that it looks different from what exists right now? And I know that's really hard with quotes, because usually you're using exact words. But you can also look at like, what else is out there? Like, how are other people using this? Is this something that is everywhere? Like, it's just impossible for them, or they clearly just don't care that other people are using this quote. So I wish I could say that there's like a checkbox somewhere where you could just like scan your design in and get like a perfect check mark, like, yay, you did it, out the back end. But that's not possible.
No, but we are going to get pretty close with that freebie that you've created for everybody.
Yeah, I love the flow chart. That was definitely something that took a couple years to make.
Yeah, so we've talked about it a couple times. So let's just bring it up. I put it right on the screen. So if anybody wants to check this out, Christina cleverly called it the copycat checklist, or the copycat. I think that's what it's called, right? Yeah. So if you go to the happyevercrafter.com/Christina-Scalera, you can get it right there. It's a free resource for all of you, so definitely go check that out. But yeah, I think we should talk about what we can do, the positive side of things. Yeah. So, and I also want to briefly talk about what to do if someone knocks your work off, because it definitely happens a lot. I think we all live in the Instagram world, and it's frustrating.
Yeah.
So
yeah. So what you can do, you can always get permission, and this doesn't have to be some formal like signed written agreement. It could just be, like I said, a DM, an @ contact in the comments. It could be as simple as going to Disney's website and reading their terms and conditions, using that control find feature. If you're not aware of that, you guys can go look that up later. But going to their terms and conditions, looking up a control find, like, can I use a Disney character? Because the big characters and quotes and associations like that own these works that we love and cherish so much, and movie quotes, things like that we repeat to each other as friends. Usually the people that own those things have some kind of procedure that allows you, or some kind of guidelines surrounding what you can and can't use. So find what you want to use and then work backwards from there, see if you can use it, or if you need permission to use it. And if you need permission, like how to do that. And then using common sense, if this is like a card that I'm lettering to a friend and it's only going to that friend, legally speaking, should I tell you you have to absolutely get permission? Sure, but that's just completely impractical, and I don't think it's necessary. So if you want to if you want to just be sure that you're not doing anything wrong ever, the best way to do this is to come up with your own sayings and quotes, and or to take something that you love and make it your own in a way that is clearly different and distinguished from whatever you took it from. It's kind of like when everybody, I don't know if you remember, like in 8th grade or something, I was concerned that I would be like ripping someone's work off if I read too much of an author or something, I would accidentally use something from them. It's nearly impossible. I want to say that it's like 99.9% impossible to state something in the exact same way, or to letter or draw or watercolor something in the exact same way that someone else has before you. So I think it's a lot harder to rip someone off than you think. But that being said, if it's just a screenshot, that's probably the most dangerous, because it's so easy to do and so common, and we see other people doing it. And so we say, like, well, if everybody else is doing it, then I'm sure it's fine. But that's not necessarily true. We don't know like what's going on behind the scenes, if they're getting any kind of notice or anything. So get out there, create your own work, or at least make that work so you that it's indistinguishable from the original. That's the safest thing to be doing. And then if your work is stolen, thanks, Becca, for bringing this up, because this is really important. A lot of people, the knee-jerk reaction is to write some kind of nasty, mean message, or if you're not a fan of confrontation, which most of us aren't, then you're going straight to what's called the Digital Millennial Copyright Act, the DMCA takedown notice. So Etsy, Facebook, and Instagram, all of these platforms have procedures and forums that you can use. The problem is it doesn't make the person on the other side of that listing or post or whatever very happy. It can actually trigger them very much so if you haven't talked to them about it beforehand. And so what can happen sometimes is any of these takedown notices or threats of litigation, like I'm going to get my attorney involved, you're going to be hearing from my law firm or whatever, these are all considered invitations for litigation. And so 20 years ago, it wasn't such a big deal. You would do this, you would just unilaterally, that is on one side only, allege that they've infringed, to get it taken down, like, boo, you stink, other person, and like gone. Now, if you do that, it's, like I said, considered an invitation for litigation, and you just never know who's on the other side of that. They could be an attorney themselves. They could have a partner or a spouse or something that's an attorney, and you could be hit with some kind of what's called a declaratory judgment, where you have to go out and answer that in whatever area of the country that they're in. So that's not ever fun. That does happen. And so my method, and I'm not saying this is what you should follow, again, this isn't legal advice, but my method when I'm dealing with this for clients especially is I like to approach it in a couple different steps. So the first step is when I find something that's infringing on a client's work, or usually the client finds it, sends it to me, is to have the client write some kind of, so this would be like you, where you don't have an attorney, the client's writing some kind of message personally from themselves. It's usually really kind, forgiving, but also at least a little bit hard on the person. So what I mean by that is it's like, hey, I know you probably didn't mean to take this, but I just wanted to let you know I have this exact thing, and it looks like you've been on my email list for 3 years, and blah, blah, blah. So those are the kinds of messages that go out first. Usually that resolves, I would say, about 50% of instances. The person's like, oop, caught with my pants down, taking to take that down, I'm gonna move on with my life. And so it's done. We don't have to worry about it anymore. I would say in about another 20 to 30% of instances, it's inciting, and the other person feels very, they get very defensive. And so that is a little bit harder to deal with. And so that's usually where I step in as an attorney. But if there wasn't an attorney there, that would be when the client is explaining to them, like, here's what's going to happen. Listen, this is like ripping me off. This is what I'm going to do. I'm going to give you whatever, a reasonable amount of time, 3 days, a week, whatever it is, to take this down. And if it's not down by then I'm going to file a DMCA takedown notice. I'm going to notify Etsy. They're going to take it down, whatever it is that might happen next. So as you can see, like the first and even second option isn't like the nuclear, like, we're going to mess everything up for you. It's just like, let's get this resolved. Please take this down. A little bit stronger version of that. And then the next step would be to get some kind of attorney or legal action involved. If it is especially something that's costing you a lot of money. So if it's not something that's costing you a lot of money, it's a really hard decision you're going to have to make, because on Etsy, it pops back up after 14 days. The DMCA takedown notice could last for longer, but again, now you're dealing with somebody who's defensive and angry and, could be saying things about you on the internet. And so that's usually the step when the attorneys get involved. So if you're at all worried about that kind of stuff, just approaching it usually from a kind but forgiving standpoint, like I said, can resolve most of those issues. And if it doesn't, then sometimes explaining to that person in a very rational, factual way is helpful. And I think the worst thing you can do in any of these situations where someone has ripped you off is to get emotional about it. And so sometimes that means having a friend or a partner or spouse or someone step in and write these messages for you on your behalf. Because what you would write and what they would write, as someone who's like one step removed from the situation, are usually pretty different.
I think that's such a good tip, because I'm not going to lie, it's happened to me before, and I get like, I can feel the blood rushing to my face, and I just get like, I can feel myself turning red with anger. So, I mean, like, I feel like there are people who are watching this that are probably really overwhelmed, and I think we're going to definitely need like a 2.0 conversation with this. But we've covered a lot, and I was actually just about to say, can we do like a little recap of like what you should do when you're thinking about creating something and you want to know whether or not it's copywritten, whatever. But I just remembered how good that chart is that you have. So if anybody wants to go and see that right now, I just popped it up on the screen. Again, you can get it on my website, _Christina.Scalera. But if you want to go right to that, you can click on this or check out this link that I just popped up on the screen. Super helpful. But we still have a bunch of questions that people have asked, and I know that this is like getting sort of long, but I want to definitely cover the people's questions that were submitted beforehand. And if we have a sec, I'll let people ask a couple more questions. So we have one from Jen, and she asked, so this is kind of two-part that I'm going to add the second part. So is there a license needed in order to sell products such as song lyrics, Bible verses? And we did talk about this. So yeah, a lot of the time there would be. So say you wanted to actually sell a product with some song lyrics on it, and you know that you can't just do that. You have to get permission or you have to buy a license. How do you generally do that? Like if you wanted to approach Hootie and the Blowfish and buy a license to their song so you could put it on a mug, like disregarding the fact that it's probably going to be really expensive, how would you actually do it?
Yeah. I mean, first of all, if you just did it and you didn't have it in the title, the actual lyric, it's just, like Hootie and the Blowfish fan club merchandise or like Hootie and the Blowfish mug. I can just tell you personally, the attorney is unlikely to find it, at least not very soon. So, especially if you're not like a super big, Instagram influencer or Etsy shop owner or something like that. So I think that's one thing. Now, yeah, to be totally on the up and up, it also depends on how much was taken. So if it's like Hootie and the Blowfish's most popular song and it's like the lyric that everybody knows them for, and it's, 40% of the song because they say that lyric over and over again, that's probably not a great one to be taking. Now, if it's just like a little tiny like lyric that doesn't really make or break the song and it's just a cute little phrase, it's very unlikely that it's going to be considered copyright infringement just because it's not famous. It's a very small part of the song, and so I think it's just going to depend. So if she absolutely needed to, there's a couple different licensing agencies. ASCAP and BMI are two that control the copyright of the songs that are out there. There's a third one, but it's smaller, and most songs are covered by BMI at ASCAP. It's BMI, and then ASCAP. I don't think it's that expensive for a license, actually. I think you can get, I mean, expensive is relative, but I think for a couple hundred to $1,000, you can get a license to their library. And so it's kind of like Spotify versus iTunes, like there's slightly different things in each library. But if you lettered a lot of quotes, or you were a very famous letterer, or your business suddenly like makes it and you're taking off, it might be worth investing in a license with one of those, depending on which song lyrics you're using, things like that. So there's definitely options. They are they are aware that we are small businesses out there, and so they do have several options available for smaller businesses. And so anyway, that's all I'll say about that. But yeah, I mean, I think safely most people could continue to use the quotes just as they have been, while they're unaware of the situation. And then once you get that warning, or whatever, the letter from one of these licensing agencies, that might be time to reevaluate things and realize you've just gotten bigger than you thought you were, or more people are paying attention to you, or you're using really good SEO, and these lawyers internally are able to find you. So yeah.
And then what about the Bible? Can we just talk about the Bible for a second? Because a lot of people asked about that.
Yeah, I mean, if you wanted to be super safe, go buy a Bible that was published before 1923. Because, like with every new edition, they change the words slightly. I think it would be, I've never heard of someone getting in trouble. Like, I've heard of people getting in trouble for songs and things like that. But with the Bible, it's so incredibly difficult to track. And there's so many versions that are already overlapping. So I think it would be difficult, but if you want to be absolutely safe, sure, you can grab a version that's been in the public domain and use the phrase that they have for the same verse in there. So
okay.
And if it's the same as the modern one, then yeah, it's not protected. So
okay. I'm just going to pepper some more questions at you, even if they're not really making sense in order right now. But so Liz asked about the ethics of sharing personally identifiable information on the internet. And so what she's referring to is, as calligraphers, say you post something in your portfolio or on Instagram of like an envelope that you lettered, and it has the person's name and address on it. And I know that a lot of people, like in my shoes, understand that that's just like a good thing to do as a human being, is to not post someone else's information on the internet. But so like, I think a lot of people make up fake ones, but is there a law or like a rule against doing that kind of thing?
I'm not aware of that, of any kind of like, the only thing I think of is like if it involves some kind of celebrity, with the right to privacy action. But I don't really do entertainment law. I focus mostly on IP. But yeah, I think it just to be safe, there's no reason to include it. Or, if it is someone's real life envelope, usually it's their name that's very beautiful, and the rest of it's just kind of like whatever. So you could either blank that out, or do some fake ones, or I mean, I've even like put envelopes over each other so you can only see like little bits of the name or address sticking out.
Put a pen over top. Put a pen over top of the address.
Yeah. So I mean, yeah, I'm not aware of anything. There might be some right of privacy action, but
yeah. So best practices for that. I mean, it's not really related to copyright, so we don't have to dwell on it. But best practice for that would be to like blank out the address or use a fake one. Or if it's something that is like you're not putting the person's address, maybe you're just putting their seating chart up, and it really is just like names that could belong to anyone. I still always ask the client if they're okay with it, which I think is like just good practice anyway. So
yeah, I love that. You ask the client in the email, you have it, so they can't later say, "Oh, I wasn't okay with that." So
exactly, yeah. Yeah. Okay. So moving on from that question, we touched on this a little bit, but you were discussing how like the best practice would be to make something as different as possible so that you're not ripping it off. But when it comes to reproducing famous things in your own style or based off a description, so that we had a really good question about this. Say you're a fan of Harry Potter and you're reading Harry Potter and you want to make a drawing of Hermione, for example. Is that allowed? Like, obviously claiming that you own the character is not okay, but if you're basing it off of a description in the book, like, is that fine?
Um, so yes and no. This is again why legal stuff is so frustrating and confusing for people because on the one hand, if it truly does look differently, which I'm not aware of any cartoon versions right now. So, if you're illustrating this, then you're illustrating it. Um, I'm not aware of any situation where that would be a problem. I think it's more a problem with like, excuse me, Marvel characters. Um, if there's any kind of trademark, which is, sorry, not copyright law, but if, for example, and I don't know if he is or not, but like if Superman or if Superwoman were their like character were registered as a trademark, I can't think of a situation where this actually is true. That could be a problem, but yeah, I don't see a problem with illustrating it other than the fact that you're depicting a copyrighted character. And um, personally, I don't think that like if you truly lettered it yourself, right? Like let's say you're really good at fashion illustrations, those are like really cool long designs, and you did like a Hermione and like a fashion illustration. Um, is that copyright infringement? Probably not. Does Universal Studios have enough money to allege that it is and do something about it? Yes. So I think it's just, even though it's not fair or the answer that people really want to look for, you could just be stepping into something that you don't want to deal with just based on that. So again, like using common sense, reasonable judgment, like if this is going out to your Instagram account of 500,000 people and you're tagging hashtag Hermione, probably not a great idea. If you're doing this and selling it on Etsy for, like the 20 people or the 20 orders you've had ever, and you're not using the name Hermione, you're just using something like influenced by Harry Potter or whatever, it's probably a lot less likely that you're going to run into trouble later. And so there's not like a clear cut black and white answer, but yeah, so I don't see a problem with using it in certain circumstances. Practically speaking, I know more conservative attorneys would say like absolutely not, like I wouldn't touch that with a 10-foot pole. But again, I think it has a lot to do with the circumstances surrounding it. So just be aware that if you're more visible, you're more likely to get some kind of warning or even action, but more likely a warning first.
Yep. We have another question from Laurel. Should you always attach a watermark or date to your images or artwork? And I also wanted to touch on the copyright symbol, like in the circle. We didn't talk about that. So when and where should you, if any, use these things?
Yeah, I like to use the copyright symbol on any presentation I do, or at the bottom of my website.
Do you have to have a registered copyright to do that, or you'd put that on anything that you've created?
If you have a registered work, you can use the circle R. So that is option R on your keyboard. I don't know what it would be for Windows. Sorry, people, but sorry, Windows people. If you want to use the copyright symbol, it's just option C. So that's what you can use to denote that. I know in your profile you have the copyright symbol, which is really smart. I like that. Just to remind people, like these are your works and your lettering. So you could do something like that. You could include it on every post that you do. You could do copyright and then your name or your business name, whoever owns that work, in the caption. So you could really put it anywhere you want, or you could not put it anywhere if you don't want to. I have a photographer friend who, she just doesn't believe in watermarks. She thinks they look tacky. She thinks they distract from the image. And it doesn't diminish her rights or her copyrights in that photograph at all. And so similarly with a lettering job, it wouldn't diminish any kind of right that you have for reposting. Now, that being said, what I will say, and she's talked about this publicly, but one of my clients, Jenna Kutcher, she was reposted, one of her like watercolor lettering I guess prints was reposted on Instagram by a bachelorette or something at some point. And so she went from having like, at the time she didn't have as many followers. She went from having like 100 views or whatever on that in an hour to like over 1 million. And it didn't have at Jenna Kutcher on it. And so that was when she started adding that, because it was obviously just good free advertising for her. So I think she's done it in a way that's tasteful, and I think you can do something similar. If you're interested, you can check out her account. I'm trying to think of who else does this. Selena Ashley designs.
I think in the world that we're referencing right now, the like calligraphy lettering world, a lot of people do videos too, and there are so many art accounts that don't make art, they just repost other people's art, and a lot of the time they don't credit it. So if you notice that your stuff is getting reposted all the time, it's a good idea. It's just like I think that is sort of a personal preference. Like there's no real rule around whether you
No,
need to
I mean
watermark
you're
things.
not losing any rights. So it's a good idea to get a little bit more get some more eyeballs on your work, especially if it is one of these art accounts.
Yeah. Okay. Just trying to see if we had any other questions. I'm going to open it up here for anybody who wants to ask some other questions. We'll just do kind of like a
Sure.
speed round. But yeah, was there anything else that, I mean, we could talk about this for a really long time, and the scenarios are so specific, but is there other stuff that you see coming up all the time that people in this world should be aware of?
It's mostly the quotes, right? Like what can I use and what can't I use? And like I said, there's no black and white thing. So hopefully the flow chart is helpful for that. And knowing that you're not going to get slapped with, I mean, I can't promise this, but you're most likely not going to get slapped with a lawsuit your first time out of the gate lettering something. You're going to get some kind of like, hey, this wasn't okay. This is why you need to take it down. So, remember that. And then permission is such a wonderful thing. You can do that. You can create relationships with people. You can just ask, like, can I repost this? And then you have a beautiful little written consent from them that you can repost it. And then, if you are looking for permission from somebody who's like a bigger account or a big corporation or something, you can always go to their terms and conditions, use that control find feature to find their copyright policy, and then figure out what you can use from there. So just to reiterate that, and then I would get out there, I would create. I wouldn't use this as an excuse not to create. I would get out there, put your work out there, find out what your style is more like, because every time you create something, you're just that much more close to finding your unique vision, your unique style, and getting away from the chances that you're ripping somebody else off. So yeah, I don't use this legal stuff as an excuse to not be out there.
I love that, because I think a lot of people are like paralyzed right now, probably watching this, freaking out that they've already made a mistake or something like that.
If you had, it's like, it's just, I think that should be a testament itself. The fact that you have been out there and you've been making mistakes and you haven't gotten caught, or no one said anything yet. I mean, I'm not saying like go out there and rip people off. That's horrible. Like you wouldn't want that to happen to you. But at the same time, like a mistake is a mistake. It's called that. It's not called like an intentional, ripping someone off. It's called a mistake because it's an oops. So.
Okay, so we're getting some questions rolling in now, and some of them are pretty good. So
awesome.
We have, I mean, we're running like pretty far over the time here, but I think it's super useful for people. So we'll keep going. Okay. So Sarah asked, how about quotes from Alice in Wonderland or Peter Pan, for example? The original books are already in the public domain, but Disney made movies out of them. So did they get a new copyright on those quotes, or can we use the original quotes from the books even if they also occur in the movies?
Yeah, that's a great question. So if it's coming from the book, word for word, if it's published before that 1923 date, then it's in the public domain. There's nothing Disney can do. Someone can make the same exact movie, whatever they want, but obviously they would do something about that. I wouldn't want to be that person that's making that movie. But yeah, I mean, there's no reason why you couldn't use quotes that are in the public domain. Now, if you're quoting the movie, that's different. So you'll probably notice that the movie has slightly different phrases and quotes and things like that. But if you're quoting the book, that should be fine.
Okay, I like it. Nice, easy, succinct answers.
I know.
Finally, for once, yeah. Okay, this one is interesting. So Nancy asked, how can we get some templates for a contract that is lettering related? And we will touch on that in like 5 minutes, Nancy, when we're starting to wrap up, because it's a whole other thing. Okay, so there's a couple that we have already touched on. Hopefully I didn't miss this, but what are the rules about quotes from interviews in media outlets? Are those off limits? I think it probably is similar to everything we've been talking about, right? So
yeah, I mean, it's like they wrote a blog post or took a picture and put it up there. It's even though it's a different like medium, it's the same exact thing. So, if ABC interviewed somebody, ABC owns that. And I think ABC owns Disney too, don't they? Or Disney owns ABC.
I have no idea. This one is interesting, and it probably is a little bit complicated. But Naomi asked, say you took a Skillshare class and you posted your work on Instagram. Do you have to ask their permission to post your work from their class? So if they're teaching you how to create something specifically, and actually I'm curious about this one because I have like YouTube tutorials and stuff where I see people posting exactly what they learned in the tutorial, and I've always wondered that.
Yeah, no, it's a great, that's not complicated. I mean, it is in a little way, but it's a great question. So if it turns out exactly like the design that the creator, let's say you or the Skillshare course instructor has created, like exactly, we could like lay it over with tracing paper and it would look exactly the same. That's copyright infringement. So for example, there's a limited license that's either, I mean, in these cases, kind of implied until it's enforced. So in the case of creating these workbooks or these courses, I think it's interesting because it's such a new area of copyright law that it hasn't been addressed yet with any kind of cases or precedent or anything like that. My gut reaction as an attorney, and this is like why attorneys practice law, is we get to make these like gut reactions based on the knowledge and the precedent we know of, is that there's this implied license. So it's implied that someone's going to buy your workbook, or they're going to take the Skillshare course or Creative Live course or whatever, and they're going to learn something from that course. And sure, as they're learning, they're going to use the exact same, like you could overlay it with tracer paper, it would be exactly the same. But what's also implied is that they're not going to then turn around and sell that thing that they just created with tracer paper out there to the world. They're not going to be like out there saying like, this is my design, this is what I'm creating. They're using it simply to learn the skill and then go out there and create other works. So as somebody who creates courses myself, like I would be more concerned that someone's out there selling my exact workbooks or courses. I wouldn't necessarily be so concerned that the people that are in my courses or workbooks are creating the exact same thing. So that's also the beauty of copyright law. Remember when I was saying like 500 people could use your thing and then the one wrong person uses it and you can enforce it against that one person? That's what's really cool about this. Trademark law is different, but with copyright law, let's say that, 1,000 people buy your workbook today and there's just that one person who goes to Xerox, copies it, and puts it online on their site for sale. Just because the other 999 people are out there copying it exactly, it's not diminishing any kind of right that you have to ask that 1,000th person to take down their competing workbook or the copyrighted designs that they've taken. So, is it copyright infringement? I mean, my gut reaction is yes, but it's not, because there's this like implied license. It would be the purpose of the course and the workbook would be completely defeated by if that were to be considered copyright infringement and enforced.
Yeah, so. Totally. Like if I think of it from my perspective, if somebody bought my workbook and learned how to do calligraphy from me and didn't use it for their calligraphy, like it defeats the whole purpose for me. So right. But I think the best practice, and well, actually you could answer this, but I would just assume as the creator that if the person is going to be posting it on Instagram and it's a direct knockoff of what I've taught them, that they should just be tagging me. And I know you had said earlier that that's kind of admitting copyright, but not in this case. If you learned it from me and you're tagging me in it, that's just appreciated by the creator.
Yeah, and if you have any questions at all, you can ask the creator, or as the creator, if you guys are out there creating these things, just having some kind of disclaimer in your workbook. So you guys have all read books and you've opened it up, and on like the 4th or 5th page, there's a copyright notice. And sometimes it even tells you in the copyright notice what you can and can't do. It says like, you need to write to this address or this email to get permission to reproduce this work in full or in part. So, you could have that, or, if you have any kind of question or concern, you can contact the instructor and say like, is it okay? That's a pretty simple, short, quick email that you're writing and just getting that permission. But yeah, I mean, I don't know anybody that would be concerned about students accessing their materials and then completing them. It's more the people that are doing it with some kind of nefarious, bad intention and attempting to copy the instructor or resell it as their own.
Yeah. So the only time I've ever asked somebody to not do what they were doing is when I ask people to post their homework and post like, a picture of their calligraphy that they've been learning from my workbooks, but I've had to ask a couple people to take things down when they're doing it on an iPad and they take a screenshot of the entire page of the workbook and then put that up, because that's so easy for someone else to just go and take and not pay for and use. And even then I felt horrible asking them to take that down, because they are still learning from it and I want them to post, and I'm encouraging people to post about it. So it's just kind of like, I think that's another case by case thing, and like just being a decent human and understanding where the creator is coming from too. Like those things go a long way.
Yeah, for sure.
Yeah. But I think we can move on from that one. So there are still some questions coming up, but I think we should cap it at that and just kind of talk a little bit about the contract shop and, where people can find you. And then we can also answer questions later on in these comments. So is there anything like up and coming in Christina's world that would be helpful for people in here to know about, or not even up and coming, just things that are on your website and things that people can look at?
No, I mean, go read our blog. We have a huge search bar at the top, so you can find any topic that you're looking for. And, if you don't see something on there, there's a couple ways to message us, let us know, and we'll create a post about it. So
yeah. And so then if anybody again wants to check out that flow chart that Christina's been referencing, it is super useful. I wish I could share my screen right now, but I can't. So you can go to thehappyevercrafter.com/Christina-Scalera, and I'll pop that up on the screen again once more. And there's going to be a full blog post written very soon about this live interview where we're going to recap everything, and I'll run it by Christina and make sure that I'm saying everything right and not using any quotes from her that I'm not allowed to. And yeah, but the one question we did get from Nancy earlier about the contracts. So we didn't touch on this, but Christina has a shop. Well, I mean, her website is called The Contract Shop, so it might be obvious to you guys what is on there. But if you are looking for contracts for using with clients or anything like that, Christina has a really good one. It's the one I use with all my clients. I send it to all my clients, and it has saved my butt a bunch of times. So I'll link to that too in the blog post. But so same website that's popped up right here, it's on there. And yeah, if you want to get a contract, you can get it from there. But yeah, there's a ton of stuff on Christina's site. And if you follow her on Instagram, she's also done some stuff with the Modern Calligraphy Summit, if anybody has taken that. So you might have seen her in there. What else are we not talking about that like you can help people with? Because I feel like there's so much.
Yeah, I don't know. I mean, I love calligraphers and I wish I were better at it. So I'm gonna have to show you guys my drills, but yeah, I don't have anything else. You guys are awesome.
Yeah, well, we're going to have to definitely get you back for like a 2.0 of this conversation. And once people have kind of put all these things into action, see if they have any other questions. But I think this was super useful for people. And we will definitely keep an eye on the comments to see if anybody has any more burning questions. I'm sure there are tons. But yeah, so thanks everybody for watching. Thank you, Christina, for being here and giving us all the law information. It's been super useful, and I'm excited to see everybody starting to post more about it.
Thanks, Becca.
Okay, I'll talk to you later.